Now let's go to the courts of law, where the commercial court has disqualified law firms of Max Advocates and AFK Mpanga Advocates from representing Bank of Uganda in a case against businessman Sudhir Ruparelia over conflict of interest and breach of advocate-client relationship. Now, in a ruling read by Lilian Buchana, Justice David Wangututsi ruled that Timothy Masembe and David Mpanga have been Ruparelia's lawyers for the last 12 years, thus making them very privy to confidential information about their former client. Here is our reporter, Samuel Senano.
Application Sudhir Ruparelia stated that David Mpanga of AF Mpanga Advocates and Timothy Masembe of Max Associates are witnesses in his defense and cannot represent Crane Bank, which has sued him. Sudhir also contends that the two law firms should not be allowed to handle the case, for they carried out legal analysis for PricewaterhouseCoopers, which was contracted by Bank of Uganda to conduct an independent audit of Crane Bank. The commercial court has ruled that the first and second respondents are disqualified as counsel for Bank of Uganda. The ruling was read by the Deputy Registrar of Court, Lilian Buchana, on behalf of Justice David Wangutsi.
The sum total is that the first and second respondents have found themselves in an adverse position to a former client. They are rightly presumed to possess confidential information learned in earlier representation of the applicant, which would be advantageous to their present client.
After the ruling, Sudhir said that he would lodge a complaint with the Law Society of England, where one of the lawyers representing Bank of Uganda is a member.
The court has said so.
And I'm going to write to the Law Society in England about the, one of the conflicted lawyers, or both of them who are affiliated in England, and expose them.
The lawyers in question are conflicted because of their fiduciary relationship with their former client, Dr. Sudhir. They are also conflicted because they are potential witnesses. In fact, they are listed as witnesses. You can't be a witness and counsel in the same case. That's the gist of the ruling. The case is not yet completed. The case will continue. The other parties who depended on them will look for other lawyers, and we move on.
Moses Adric of Max Associates revealed to court that they will appeal the... In October 2016, Bank of Uganda took over Crane Bank and later sold it to DFCU Bank after suspending all its board members. Bank of Uganda also took Sudhir Ruparelia and his Mera investments in court, seeking to recover about 400 billion that he allegedly took from Crane Bank for his personal gains. Samuel Senono, UBC News.
Thanks, Senator, for that report. And in a related development, AFK Mpanga and Max Advocates are to appeal the ruling by the commercial court that barred them from representing Bank of Uganda in the Crane Bank Limited receivership versus Sudhir Ruparelia court case. Now, in her ruling, Deputy Registrar Lilian Buchana, on behalf of Justice David Wangututsi, held that Sudhir was Max and AFK Mpanga former client, so representing the current client, that is Bank of Uganda, would be advantageous to them. It is alleged that businessman Sudhir Ruparelia diverted over $96 million from Crane Bank to his own businesses, and therefore directly affecting the bank's operations. Danny Sigoa reports.
The commercial court has disqualified law firms Max Advocates and FK Mpanga Advocates from representing Bank of Uganda in a case against businessman Sudhir Ruparelia over conflict of interest. In a ruling read out by Deputy Registrar Lilian Buchana on behalf of Justice David Wangututsi, the court held that the two law firms are privy to confidential information regarding Sudhir, and therefore representing Bank of Uganda would be unfair. According to the ruling, Sudhir, who is the applicant, was the client of respondents 1 and 2 for close to 12 years, and in representing and advising him, they became aware of facts which could be judicial to him. However, David Mpanga of FK Mpanga Advocates argues that the ruling was improper.
The case that is in court is essentially the exercise of trying to get or recover the money, taxpayers' money, which was put into Crane Bank Limited in order to keep it afloat. So who the lawyers are, what the Bank of Uganda may have done or not done, and all these other things that you've been hearing in social media are sideshows. The critical point is that a bank collapsed, a large bank collapsed. Losses were incurred. Those losses were borne by the taxpayer. The taxpayer needs to pay.
The two law firms want to appeal the ruling because they believe that the judge did not consider the facts and the law.
And we think that there are fundamental issues to be at stake here, especially in respect of how a party can choose or veto counsel of another party.
Sudhir was personally in court shortly after the ruling, said he will lodge a complaint with the Law Society of England, where one of the conflicted lawyers is a member. Dennis Igoa for UBC Business.